It is April 27th of 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Today we start with Judge Middleton revealing how a defendant tried to bribe him by showing up at his house with a beer. Then we see the sentencing for a repeat DUI offender the prosecutor calls a lost cause. Then family court drama explodes with a dad accused of sending unhinged texts to his daughter and a mom whose new work schedule puts her 19-year-old son in charge of everything. But nothing will prepare you for the end when not one but two defendants have complete meltdowns, both shocking Judge Stevens with their brazen, bizarre behavior. It's been an unhinged day in court, ladies and gentlemen, and it all starts right now.
Good morning. It's Monday, it's the 27th of April. We didn't have anything until 9:30 this morning, and I couldn't figure out why. And I realized I had blocked out the first part of this morning for a dental appointment to get my teeth cleaned. My dentist got hit by a tornado, and so my appointment got canceled. They're still not open. They're all still boarded up. They have a new roof. So 8:30 to 9:30 was blocked. So we have one general civil pretrial here in just a couple of minutes. We do have a couple of special guest visitors here from California. And I haven't turned the record on. All right. And we're still getting used to our courtroom. We did both utilize it on Friday, and I'll be here today and tomorrow, and Judge Patterson will be sharing it also. But it's a privilege to be in here, I consider it, and we're going to continue to work on it. Got a nice email from Stingray Tom this morning. He has a YouTube channel, and he and I had a nice conversation in Florida. He posted that on his YouTube channel if anybody's interested in that. My docket is not very long today, although it's full in the afternoon. I've got people in the courtroom, and there's an interesting wrinkle with the case that we're going to do. The chair I've got is adequate. I still need a booster seat, but I think we'll be all right. Today's first line. I hope you guys liked Rocky Vadalato, White Daisy Passing. Had you ever heard the song before? Well, I did that for you guys, so that's a new song to add to your catalog. Yes, there's major construction going on. So they're in the waiting room. We got to start. So today's first line. I'm packed and I'm moving. Smiling, she's living, she's golden. She lives for me. She said she lives for me. Ovation, her own motivation. Leave it at that. Ovation, her own motivation. She lives for me. She said she lives for me. Say it real fast. Do, 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 do. That's actually the first line of that song. All right. I hope you like that one. And let's shut off the live chat. Thank you very much. Still working on our view versus gallery view. I understand some of the things from Friday in the little room were weird. It went under my radar. We had an absolutely beautiful, sunny, 66-degree weekend here in Michigan.
Where the heck are you?
Good afternoon. Does any of this look familiar to you?
It does not. Where are you?
I'm in outer space. I'm sitting in Judge Boyle's seat.
Oh.
You're in that conference room, and I apologize. We could have just brought you in here.
Okay.
Yes, Andrew, we have transitioned to the historic circuit courtroom, the commissioner's room. I will be using this room much of the time. Judge Pattison will share it with me. And so here we are. Is your client here? There he is.
Just pulled into the parking lot. However, let me make a suggestion. I may talk to him about making an offer of judgment. Just agree to a judgment for the amount of $1,000. We can get this wrapped up.
All right, well, let's take a minute. I think he just came in. Is he there behind you?
I don't think so. Oh, yes, he is. Okay, he is now.
All right, well, let me call the case. This is file number 252053GC. It's entitled Heather Culbert versus MRD Singh. Heather Culbert is here at the courthouse. Rather than bring her in here, they put her in the conference room. I guess that does facilitate breakout rooms if we need it. Ms. Culbert filed this matter as a small claims action, claiming that the defendant owed her $2,500 over a deal with a cell phone. Plaintiff filed the action. Mr. Rognes filed an appearance on behalf of Mr. Singh and removed the matter to the general division of the court. Filed a counter complaint for approximately $17,000. I sent the matter to mediation, and thank you to the people at Citizen Mediation Authority. They took a attempt at resolving the matter and advised me they were unsuccessful in reaching a settlement at mediation. So we have the defendant's original claim for $2,500, the counterclaim, excuse me, this chair a little wonky, for 17,000 something, and we've not resolved it, so the matter is here for status conference to see how we proceed further. Ms. Culbert, thank you for agreeing to participate in mediation. Did you get close, or were the parties still really far apart?
I believe the parties are still very far apart, sir.
Boy, it's really hard to hear you from that room. Mr. Rognes, what's your position?
Your Honor, I was uncertain what the court wanted to do based on your letter from, I can't remember when it was. It looks like you had sent an email out to everybody about some content that Mr. Singh had with you. And rather than bouncing this out to a different judge, potentially in a different county, we were seriously considering making an offer of judgment. I think I had talked to
All right, well, let me stop you for a minute. Let me recap. I was sitting at home one evening. I think it was a Sunday. I don't remember. Anyway, I was at home with my wife. Knock at the door. It was your client, Mr. Singh, who came to my house, knocked on my door. I came out and greeted him. And I know him because he owns the store around the corner from my house. And he wanted to take me out to brunch. It was 6 o'clock at night. And I said, well, I can't go to brunch. I said, I'm here with my wife. He said, well, your wife can come too. I said, Mr. Singh, I can't go out to dinner with you. You have a case pending. He actually has 2 cases pending. You wish to I can't talk any business with you. He kept touching me on the shin. He said it was a sign of respect
I think
in
that's
his culture. Anyway, I said, I can't go out with you. I don't want to be rude, but you have a case pending. He'd been drinking. I could smell alcohol on his breath. He drove to my house, and I think his driver's license is suspended. Anyway, he left. Then he came back, and about an hour later, somebody knocked on the door again. Again, it was Mr. Singh. I said, I can't talk to you. You have a case pending. He had 2 6-packs of Bell's Two Hearted Ale. He set the beer down and left, drove away. So I have 2 warm 6-packs of Two Hearted Ale, which, Mr. Rognus, I'd like to give back to you. So I shared that information with you and Ms. Colbert, and that puts us all in an awkward, uncomfortable position. Because of that, you're willing to discuss a possible settlement.
Yeah, just potentially make an offer of judgment. I did.
All right, well, let me put you in a breakout room where you can talk privately with Ms. Colbert regarding that. She didn't seem real receptive to it, but there is a substantial counterclaim. Ms. Colbert, this room is new. Hopefully, when the computer comes up to says join the breakout room, click that button that says join. That's why you're in the conference room, so you can talk privately with the other side. Those 2 little temporary structures out there, fiberglass and aluminum, are the 2 conference rooms that we're using as Zoom rooms. And we had used the Zoom room extensively, as you know, with all kinds of things. So they made 2 of them. The walls are tissue thin. You can hear through the walls. They have like a 2-watt bulb in there. It's so dark you can barely read your watch. Anyway, they put her in there, which is fine in light of the fact that we needed a breakout room. But they're not ideal. Much of what we're going to be doing here for the next year and a half will be not ideal. And I've been to Three Rivers a couple times last week, and everybody, from corrections to the clerical staff, to the judges, to the custodial staff, everybody is just doing the best they can. They're not complaining. They know it's going to be difficult and inconvenient, and they're all just trying to make it work. So I'm proud of everybody around here. My staff's doing a great job. As you see, they're all crammed into that small space. The prosecutor's office is spread over a couple different floors, and Judge Kane is doing a lot of circuit court cases. I'll be doing a circuit court case later this month. I think I'm going to try a solid intent of murder case in May, 26th or something. We're all trying to just keep the ship floating and pointed in the right direction. It's not as bad as it was. There was junk all over the place and stacks of drywall and stacked up furniture, and we're still working on the details. We kind of got this courtroom situated. We got those nice panels over there to hide some of the file cabinets, and I'd like to get rid of those 3 televisions back there, and we stuck those in the corner, and that's the jury box, such as it is. Anyway, this room, I've got the best of it. I've got this courtroom, which is immediately adjacent to my office. But Judge Patterson's got a nice office, but a very small little courtroom. Anyway, we'll make it work. I have to just survive until December. They probably have another year or more beyond that before the new construction is done. But when it is done, it will be very nice and modern and secure and hopefully all the things you want your courthouse to be. It does appear we're going to get another quasi decent April day. It can do anything in Michigan in April, including snow 2 feet or be 85 degrees out. The days we had Saturday and Sunday were just ideal. Perfect spring day. The flowers are coming, the pollen's all over the place, but it was in the upper 60s and no wind. Very pleasant, full sunshine. It make it colder this week. It gets windy sometimes as the season changes in the spring. Days are longer. It's not Florida in April, but it was pretty good. Florida, when I was there in April, was perfect. Postcard perfect for 10 days. Of course, the people in Florida want rain. All right, parties are back. Mr. Singh isn't visible in the scene, but he is there. And Mr. Rognes. All right, Mr. Rognes, did you make any progress in the
Yes, we
breakout?
did, Your Honor. I am going to submit a judgment in favor of plaintiff and against defendant for $2,500 under the 7-day rule. I explained to Ms. Culbert what the 7-day rule is. If she doesn't have any objection to the language in the proposed judgment, the court will enter it after 7 days. If she does have an objection to the language in it, then she needs to file a written objection and then have it. That way we don't end up spending tons of money on this thing and bouncing it over to another county or different judge or whatever.
All right, Judge Patterson would have agreed to taking it. So if I understand it, Ms. Culbert, the defendant is going to confess judgment to you in the amount of $2,500 flat without costs. He will drop his counterclaim and pay you $2,500 within how many days, Andrew?
Oh, I'm not certain. We'll get through the judgment and let it go at that, and we'll get her done eventually. I don't think he has the money right now.
Ms. Culbert, do you agree with those terms? You will accept a settlement for $2,500. The counterclaim would be dismissed. Mr. Rognes will send you an order under the 7-day rule, and it would enter. Now, the judgment is an order that says he owes you $2,500. There may be some effort made to try to collect on it. But do you agree with those terms?
Yes, sir.
Are you still at Cushman Street?
Yes, sir.
I still got the dilemma of 2 6-packs of beer that I don't.
Lucas will take them.
Say that.
Lucas will take them.
I suppose I don't like too-hearted IPAs, but I got it. I'll drop it off at your doorstep, and then you can.
But isn't Lucas a big Hemingway fan? That's where the name came from, the Big Two Heart River.
Yes. Well, all right, we'll resolve that, but this resolves the case, so we won't have to disqualify me or assign it to Judge Patterson or another judge. Mr. Singh.
Yes, Your Honor.
All right. As I said, I'd stopped going in the store because you kept trying to give me stuff. Our culture is different than your culture, and you can't interact with the judge who's hearing your case. You can't offer gifts or gratuities to the judge that's hearing your
I
case.
didn't give you because of my case. I just respect you. I give also gave right next door to you.
All right. I don't think we got any of that.
all the people.
All right, Mr. Rognus, I will wait your order under the 7-day rule. Ms. Culbert, if he doesn't pay, you can pursue a discovery subpoena.
Okay.
All right, you're free to go. We'll send you a copy of that order in the mail.
Thank you very much, guys. Have a great day.
All right, thank you. All right, we are back. We're prepared to start the sentencing in the matter of People versus Xavier Edgington. File number is 252499FD. Mr. Edgington is here with his lawyer, Mr. Victor Bland. He was charged with operating while intoxicated. It was charged as a third. Oops. People versus Xavier Edgington, file number 252439FD. Mr. Edgington is here with his lawyer, Mr. Victor Bland. He was charged with operating while intoxicated, third offense, and I don't think it was correctly a third. I think it was a second offense, and the defendant pled to that charge. Also present is Abby Stoll from the prosecutor's office and Priscilla Walton from the probation department. We had a brief meeting off the record here a minute ago. Mr. Bland wanted to make sure we had all our information correctly. And now it's time for the sentence. Mr. Bland, what would you like me to know?
Well, Your Honor, some of the things that we've discussed. Obviously, the first point was I was charged as a third. I think it should have been charged as a second. I pled to a second. Technically proper, but certainly if we were to use the old grid scoring, that makes a difference in terms of the maximum sentence. And I think that was noted in the pre-sentence report. I think, to make a long story short, I would like to follow the pre-sentence recommendation. And I realize, Judge, it's a recommendation, and it's ultimately up to you. I think it was well written. I think it was sensitive. I think it was intuitive, and I think it covered all the points. Why does that recommendation make sense? Well, to me, the number one reason is he tells me he's been 5 months sober. He tells me that he has been doing breathalyzers 6 times a day. Now, there's an issue with this terratum I don't fully understand. I think the court and he are going to have an understanding on that. I will say, from my point of view, no, he shouldn't be doing keratin either. His child just got released from the hospital today. It had RSV. It's a child that he and Ashley have. I think the child has turned the corner, but obviously that is a concern for him. He tells me I don't know whether he's actually in classes or signed up at Glen Oaks, but there's some association with Glen Oaks. Because of the PTO that's existing between he and Ashley's son, not he and Ashley, he has signed a lease with a separate residence. And, some of these things are factors for why he would ask if the court were to incarcerate him, which, again, we don't believe is necessary under the recommendation. He'd be given some time to work some of these things too. True. He tells me also that he has gone and, I think, talked to the work release people. I'm not sure where that was. He thinks he's on the way to being set up with that. Tells me he works at, I think it's Alleges Investments, which, despite its name, he tells me is a construction company, and I don't know if he's actually went to work there or not. I know there's a concern about the LaGrange warrant. I know the recommendation gave him time to take care of that. That's what I would certainly ask the court to do. I understand that to be a misdemeanor failure to appear in an OWI. I think it's a first offense OWI in Indiana. And I think they have kind of like a work release weekend, sort of, where I think he goes in on a Friday and he's out on Sunday. And
At where? Where?
In LaGrange.
Okay.
I'm sorry if I said it.
I misunderstood.
In LaGrange. And he did not go to that, not because he didn't want to go back to LaGrange, but he tells me he was arrested on a warrant, or turned himself in on a warrant for St. Joe County for domestic violence that was eventually dropped. So I don't want to it's what I call a technical abscond, but he should have turned around and made it right with them. But he didn't. I think the important part I want to get through is that it wasn't sort of willful. I'm just not going to go back and take care of it. However, he's had some time to do that. So to me, one of the things that you want to do with the sentence is you want to make sure you get somebody on the path of reform, on the path of taking care of their issues. And I realize if there comes an issue, and I'm not trying to talk around that, other than to say, I'm pretty impressed with 6 breathalyzers a day. I don't know how long that's been going on. I'm pretty impressed with 5 months sober. And I understand also he's on Suboxone. So my plea to the court would be that we follow the record. He's told me in the past that he has been incarcerated here in St. Joe County. I know I represent him on at least one of those. And LaGrange didn't come get him, and maybe because of the fact they look at this as just a first offense OWI, but that's their reason. I understand. So in any event, Judge, long and short of it is, I think there's reasons to back up the recommendation. I would ask that you follow. Thank you.
All right, I've got a lot of questions here, and I'm gonna start with some of those. Mr. Edgington, you have, since when this first came back, you've had this open warrant from LaGrange County. My fear was LaGrange was gonna give you a year in jail, which is why I think you were afraid to go down there. But you've known for a year or two that there's an open warrant for you in LaGrange. You also had a charge pending in Elkhart County. What happened to the Elkhart County charge?
From my understanding is that is 13 years old. When I was arrested for the OWI, I had asked them about it, and they said that it was that I didn't have. I asked the police officers, and they said that I didn't have a warrant. While I was serving time in prison, I had written them and asked if I could do a plea by mail. And they responded that upon my release, come see them in 30 days. My parole officer denied me access to go down there to do so on the basis that it was a misdemeanor. But later, I was arrested for the OWI, and the officers had told me that the warrant was that there was no warrant.
Your felony PSI indicates you have a pending charge of no license handgun in Elkhart County, Indiana. And it says you have charges pending in Elkhart and LaGrange County. The LaGrange County is a drinking driving charge that you never appeared for your sentence. Those are 2 large factors why you weren't placed in sobriety court. You have open warrants for you from another jurisdiction. And I don't take everything you tell me at face value. All right, let's talk about something else. You told me and you told Priscilla that you worked at Basin Materials in Sturgis. Did you ever actually work there?
I did not end up taking the job. The day I was supposed to start, I was offered the job at Esch Investments. So it would pay significantly more. So I had taken that job instead.
I don't believe you. You told me you were working on 2 different days, like weeks and weeks ago. You told me you're working at Basin Materials. And then you told Priscilla that. So tell me about Esch Investments.
It's his name's Matt Esch. I can give you his information. He can the probation department or the Twin County just spoke with him, and I was accepted to work release.
Well, how'd you get to Twin County? You went to Twin County on your own to set up your own work release?
Yes, sir. That's how I've done it in the past.
See, Basin was a lie. You told me on 2 different occasions you were working there and you were offered it. You weren't working. And when is the last time you actually worked?
Thursday
Which was where?
at Esh Investments.
All right, I was told you were gonna start today.
No, I'm supposed to go back to work today.
When did you start there?
I have been working there for 2 weeks now. I was supposed to start the job at Basin, but like I said, I was offered this other job and I had taken that. I have messages, I have my boss's number, to back that up.
All right, so there's the issue regarding your employment. There's the issue regarding the Elkhart County warrant. There's the issue regarding the LaGrange County warrant. Let's talk about Glen Oaks. You claim to be enrolled as a student at Glen Oaks
Yes, sir.
Community College. I'm not sure I believe that.
I
either.
have my ID in my wallet right
Well,
now.
an ID is one thing, and it's one thing to enroll. It's another thing to actually go to class. You've been telling me that you're working at Basin, and you're telling me you're doing something else. When's that last time you actually went to Glen Oaks to take a class?
I do online.
Uh,
My professor is Stephen Rhino. That's my English class. I just had an assignment due last night, but I did not have the time to do it, so that assignment will be late.
so you're taking one class?
Just currently, I was enrolled in 2 classes, but I realized that algebra is a bit harder than what I remembered it being from high school, so I dropped that class in hopes to get.
So you have one online class at Glen Oaks, which you're behind in, which is a lot different than actually being enrolled as a student. Abigail, what's your thought here?
Your Honor, in my opinion, the defendant is a lost cause. He's had prior probations revoked. He has as the court's aware, he has the current warrant out of Indiana, and his prior OWI conviction is only 2.5 years old. In the instant case, his BAC was over twice the legal limit, and he had a utility pole. So, in my opinion, I think the only appropriate solution or punishment is upfront jail time.
In his pre-sentence report in the circuit court case, the pre-sentence writer states under recommendation, this is a couple convictions ago, Xavier Edgington is before the court on his 2nd felony conviction. He has 15 misdemeanor convictions. The defendant has been placed on probation 7 times, with 6 ending in revocation. He's failed to begin his 7th probation term, as he neglected to turn himself in to the LaGrange County Jail as instructed, and his probation was scheduled to begin upon completion of his jail sentence. Such lack of compliance has resulted in the defendant being charged with a misdemeanor, failure to appear. Defendant having been released from lawful detention, the misdemeanor failure to appear. He also has a pending misdemeanor of Elkhart County, which he was also ordered to report to the court within 30 days of his release from the Michigan Department of Corrections. He has failed to do so. He has also received jail sanctions and 1 prison commitment in a commitment to the past. So at that time, you did have a LaGrange County case and an Elkhart County case, and I don't believe your explanation of either one of those. You have been taking a breath test every day, but you're also using kratom, hillbilly heroin, and it's expensive, and you're taking it every day. And now you're on Suboxone. Who put you on the Suboxone?
Pivotal.
To help with withdrawal from the kratom?
Yes, sir. I've been off of that for almost 2 months now.
All right, Priscilla, I'll give you the last word.
Your Honor, I believe that you yourself and Crystal has said what I need to say, but my recommendation was based on that, yes, Mr. Edgington has a lengthy criminal history and a history of having probation violations revoked. I was on the fence of this as to give Mr. Edgington another chance of probation, but I'm willing to, if the courts decide to place him on probation. I would like him, like I stated in my recommendation, for him to take care of his warrants that are active out in LaGrange and or Elkhart County. The only issue that I had was, I am aware that Mr. Edgington has the issue with Kratom. He states that hasn't used it for 2 months. But if he were to relapse, I don't, it could be an expensive test if I were to send him over to day reporting center. That's my only issue with placing him on probation. But as to why I also gave him, 20 days deferred. So if he is unsuccessful from this probation, he has that chunk of jail over his head.
Judge, I think he wants to address the keratin.
Go ahead, Mr.
That is something that I struggled with. I did not understand exactly what it was at the time. But like I stated, I have been off of it for some time. And I've been working with Pivotal diligently to maintain my sobriety.
Is that sobriety from all substances?
All substances.
Do they test you? I'm sorry, Judge.
I have not been tested for anything, no.
Well, you're doing the PBTs, but that's through the corrections department.
Absolutely, yes, sir.
All right. Nobody's testing you for the keratin.
No, sir.
Okay. But you, just so we're clear, you believe you've been off of it for 2 months?
For some time now, yes.
And what caused that? What was the light bulb going off?
With me getting sober from alcohol, that was my number one thing. I understand my record is lengthy and it's terrible. And I don't contest that. I have turned it around. I'm training for a crew lead position, which pays upwards of $40.
Training for what kind of position?
A crew lead. It's Ash Investments is a construction company. It's on the corner of Featherstone and Schimmel. I was just speaking with my boss before I came into court to let him know what's going on. It's somebody that posted a job on Facebook. I have W-2 or I have check stubs to prove my work. It is a taxed job. It's not a 1099 or anything like that. Having this baby, I have 3 other children and I don't have rights to any of them, but with the baby I do, or I'm not on the birth certificate yet, but I'm going to be. But the baby has changed my life.
What's the due date?
For the baby?
Yes.
January 3rd, 2026.
Okay.
Her name is Sophia Marie Edgington.
Yes.
So she's already born.
Okay, she is born.
Yes, we were just.
I guess she wouldn't have a name of Sophia if she wasn't already born. So
we were just released from the hospital this morning. We've been in the hospital since Thursday night. We went to Sturgis and then we're transferred to Bronson. And I have release papers that I had left the hospital and came to court. My fiance's father came and picked the baby up, so we were able to come here. And then after court, I was supposed to go back to work. I understand. On paper, I look terrible.
well, there's one thing you left off. when you got arrested, you threw Ashley under the bus. The first thing you said to the cops was, Ashley was driving, I was not. Like, how bad is that? You're a 178. You crashed into a pole. You tried to blame it on your girlfriend. Yeesh. People saw it and saw you driving. You should be ashamed of that.
And I am.
All right. I'm gonna allow work release.
I will say the arresting officer in the case is the one that came, tracked me down to tell me about that I was being mischarged. That is Officer Cleaver of the Sturgis PD. And I've had a few contacts with him since, just in checking on me and telling me that he's proud of my sobriety and that
Now, somebody who was in your corner was Betsy. She always was supportive of you. I should pass that along. But I don't know what point you quit. So also you were under 7-0 Kratom when you had this wreck. And then you were going through withdrawal. You were spending $200, $500 a week on Kratom. I'm not gonna do a probation because I'm not gonna set you up to fail, and I don't believe everything you say. You need to go take care of your Indiana warrants. I don't believe that you're much of a Glen Oaks student. You've got one part-time class that I don't even know if you have a 1 credit hour accomplished. I'm gonna order 32 days, credit 1, leaving 31 days to serve, which may be served as work release. All the money I take from you is money away from your family. So the fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee.
Your Honor, I'd like to amend that Sturgis PD is requesting restitution for $255.
All right, there is no attorney fee. Mr. Bland is retained. And I will say your employer has been a very vigorous advocate on your behalf. But at some point, you got to own your own stuff. You're 2 times drunk, you're using Kratom, you crash into a tree, you tell the cops it was your girlfriend. You have an open warrant from Indiana and LaGrange County, an open warrant from Elkhart County, PPO against you. Nobody inflicted this on you. You did it all to yourself. So I'm going to let you do this. We'll confirm that he actually has a job at Ash Investments.
Judge, he's asking that he can report on Friday.
Yeah, I'm going to 2-month non-reporting probation. Priscilla will set this up. That way, if you don't go to report for your sentence like you did for Elkhart and LaGrange, I'm going to give you 365 days. So you set up work release on your own without even our knowledge, but I'm not going to oppose it. Let's see how much you owe me. 125. No probation oversight fee, 255. $380. That's due by June 30th. There's also a cost of being at probation center.
I don't mean to quibble, but originally I heard the court saying that you weren't placing him on probation.
I'm not. I have a 2-month non-reporting probation. And so if he doesn't show up for his sentence, that'll be a probation violation. And I will have a probation violation hearing and impose the maximum sentence. So you need to show up. Two felonies and 16 misdemeanors, plus a couple other things that are uncharged. I hope you have turned the corner. I want you to meet with Priscilla and she'll coordinate what's going on with the Twin County Probation Center. All right, you're good to go.
Thank you, Judge.
Give that to Priscilla. All right, it's 12:18. Could be worse. All right, let's do Regina Harbin and we'll free up Mr. Knopfinger. This is file number 252466ST, People versus Regina Lorraine Harbin. Once again, Mr. Knopfinger is here with his client. Matt Huff drew this assignment. And once again, Abby Stoll is here from the prosecutor's office. Good morning, Ms. Harbin.
Good morning.
Mr. Huff did a good job in preparing the screening report, as he always does. He raises some issues which I had concerns about myself. Mr. Knopfinger, what would you like me to know?
Yeah, a couple things, Judge. Miss Harbin is not a spring chicken. I think this was after a Detroit Lions game. I think that there were some health-related aspects that contributed to this intoxication. I think she learned a serious lesson that day. We reviewed the recommendations. She is agreeable to a term of probation. I am not sure if 12 months is necessary. I'm not sure if Mr. Huff is convinced that it's necessary either. I think maybe he's considering the division of probation if a probationer is in good standing, and he references the 6 to 12 months. With that being said, Ms. Harbin is agreeable to that term of probation. She will have some license sanctions that she was well aware of coming into this. So I would ask the court to consider all that in sentencing. We're aware that there's statutory presumption. There was an accident that I can understand the court could deviate from that, but we would ask for any leniency that the court is willing to grant. Thank you.
There's a presumption in most misdemeanor cases that there'll be no jail and no probation. That wasn't my idea. That's the wisdom of the Michigan legislature. But there are some exceptions in drinking driving cases where there is an accident. That presumption does not prevail. And the judge has discretion anyway to go over the presumption, but we're to start with the presumption that you won't go to jail. Matt is not recommending jail, but he is recommending deferred sentence and a probation. Now, you and I have met over the years. I'm considerably older than you are, but we're neither one of us, I guess, are spring chickens. But you had some issues years back with methamphetamine, and I think you put that long since behind you.
Yes.
I don't think methamphetamine is a factor in your life right now. Is that accurate?
That is accurate.
But Matt and I both had a concern that you drink more than you were acknowledging. We were concerned about how high your blood alcohol level was, 0.207. And you need some practice to get that high. That's 2.5 times the legal limit. You peed your pants. It was not good. You had an accident. Now, true enough, you didn't have very far to go.
Yeah, I was right across the street from home.
Well,
Yeah.
But you could have killed yourself or somebody else even in that short distance. You were driving from East Street to Lockport Township, townhouses, which would essentially be a drive down Hoffman. But you were on a side street when the accident happened. Matt, would you like to add anything to this?
I think you've covered everything that I would like the court to be aware of.
Abigail, you have anything to add?
Your Honor, I would just let the court know that our office reached out to the homeowner and we didn't hear back from her regarding restitution for the mailbox. We're not asking for that.
I don't think it did too much damage to that fence, but you're right, Luke. They declined to reduce this to impaired, so it's an OUIL, which means she can lose her license, and that's in part because it was 2.5 times the legal limit. So if I do a 12-month probation, she could be discharged at the end of 6. I think that's probably appropriate. I'm gonna do a 12-month probation, 9 days jail, credit 2, leaving 7 days to serve, and of the 9 ordered, 7 are deferred. If I gave you a test right now, what would it show? Anything? If I give you a drug and alcohol test, what would it show?
Well, I was forthcoming with
Yeah.
Matt, that I do use THC and CBD gummies and for
You're gonna have
pain.
to set those aside. You're
Pardon?
gonna have to stop unless you have a medical
Yes,
card.
and I
I mean, it's lawful. It's not against the law, but so in addition to alcohol, you also had THC in your system. I think a high percentage of our drinking driving cases also have a THC component that we don't even completely understand. People are drunk and high. Anyway, you are the kind of person that doesn't really get in much trouble. And you don't like coming over here to see me, although you're always very respectful when you do. But we'll call this a timeout probation, where no drugs, no alcohol, you keep your self in order, and it will go away. But it's expensive. It's $300 fine, $75 crime victims' rights fee, a $50 state minimum fee, $100 screening fee, $150 attorney fee, $480 probation oversight fee, which will be reduced by $240. Abigail, do you have any police reimbursement in your records? Tell you what, I'll waive the fine and make it a 0. That'll reduce things by 300. And it doesn't look like there was a police reimbursement.
I don't see one,
So
Your
that's
Honor.
gonna save you another couple $100. Somewhere in the move, I lost my calculator. I got this big dumb one. 855. It'll reduce by 240. There is no, oh, I do have $200 of bond. So that's 655 is 655 minus 240 is 415 in 6 months. All right, as a condition of your probation that you not use any drugs or alcohol, take a test as directed. You didn't order the victim impact panel, and I won't put it in there. I guess that's it. We're working part-time. Are you still doing that?
it's not. Yeah, it's a mixture. It's not for a company. I just do home care for a senior. And that's just a supplement.
Well, and that person probably appreciates your help, but you're gonna have a logistical problem getting back and forth to work. All right, I want you to go with Mr. Huff. And we'll get you plugged into this probation. All right, you're good to go. All right, Mr. Bland is like a boulder in a stream, and he wants to talk to us. So we're going to stop the record here for a minute. Close the live feed. And he's determined to ruin my lunch hour today.
File number 194359DS. That was consolidated from 145909 DP. Nonetheless, it's captioned Zuniga versus Witkin. It looks like we have Miss Jessica Zuniga here with us today. Good morning, and then Cody Witkin is here as well. The parties are operating off an order that the court signed back on April 24th of the year 2025. With respect to their two minor children, Lillian and Grayson, the parties were to share joint legal and joint physical custody. And they've sort of had a blended schedule, a couple days on, a couple days off, and then alternate weekends, but they were ultimately ordered to share custody. Ms. Zuniga now has some concerns with respect to the viability of that continued schedule and asked the court to consider changing both physical and legal custody. So what we're going to do today is first the court is going to decide whether or not there's been a material change in circumstances or a proper cause to address that custody order. If it needs to make any temporary adjustments while it goes through the process, then it would do that too. So we'll get started, Ms. Zuniga, with you, if you would join me at the podium. Mm-hmm. You can bring your materials with you if you like.
Okay.
Good morning.
Hey, good morning.
Would you raise your right hand with me?
Yes.
Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. You may put your hand down. I have had a chance to read your petition, and I understand kind of what's going on.
Okay.
So you can fill me in.
Yeah. So my primary goal is obviously to establish a stable and safe and comfortable environment for the kids. This matter, however, involves just the ongoing disputes regarding the parenting time communication, the need for accurate child support determination between the both of us. We do share the two minor children, and we're subject to that existing custody and parenting time order. But since the entry of that order,
You're not reading to me, are you?
No, I'm browsing. I'm so sorry.
Yeah, well, let's just why don't we just have a conversation?
Yeah. Okay.
So the children have been primarily with you?
Yes.
Since when? Since March?
So since March 17th was when that was the day that I had to go pick them up from his house. And since then, it was April 11th that he started regularly exercising the parenting time again. Up until that point, there was ongoing disputes between him and his parents, and with that being his primary residence, I was told on several occasions not to bring the children over there, and there were times when I did. That parenting time was interrupted and I had to go pick them up or make arrangements to pick them up early. Eventually, we eased back into the schedule mid-April.
So you're back in your normal
We are
schedule?
right now, yes.
Okay, but you still have concerns?
I do still have concerns.
Okay, and what are your concerns?
Right now, it's a lot of the communication disputes. The app close, I feel like, is being used inappropriately.
How so?
A lot of the, so I have with me too, a lot of the different exhibits, but a lot of the venting on the defendant's side is going through, like as far as just rehashing things from the past and maybe relating those to things that are going on now with our children and concerns that he has with the children, but it all kind of intertwines with our past and our issues. And I've tried to stop that conversation quite a few times on the app, and he's tried communicating with me like via our daughter's cell phone too. He has another cell phone that he'll try to reach out to me and like send audio messages to me, which I haven't listened to or anything. It's just, my focus has just been on the kids, especially since this mid-March incident. And there's been a February incident as well, where there's just been a lot of discombobulation and a lot of, things that weren't really, what's the word I'm looking for? Sorry, I'm just a little nervous. We just weren't able to do the entire like parenting time thing in a stable way. And so the kids were having to go with me, which was fine. I had to take off time from work to do that, but they did have to stay with me during that time. And now they're going back over there. They have shared some concerns with me about going back over there too, which...
Does he live with his parents?
Mm-hmm.
And he was out for a while, according to your motion, but then he's back he's back there again?
Yes.
But you trust his parents, right?
I do.
And you don't have any concerns when the children are at his parents. You have concerns when they're not at his parents.
Like, what do you mean as far as with him?
If he has them not at his parents, then you have concerns.
More so than.
You need to stop.
Okay, I'm sorry.
Okay, you need to stop, relax. You will have an opportunity to speak, but please stop.
Okay, sorry.
Okay? All right. Go ahead.
Yeah, so I don't know where I was at. I'm sorry.
Pardon me?
I don't know where I was at with all of that.
Question was,
the concerns.
My question was, you have concerns when he has a children, but he's not at his parents.
Correct.
Correct?
Yes.
And you allege that he was taken to like a behavioral health.
Yes, he was admitted to Sparrow on around that same time, March 17th, and I have verification from his dad saying that he was sent to Sparrow for a 72-hour psych evaluation. After that, he was sent to an outpatient place, but I don't have the information on that.
For a mental health disorder?
Yeah, that's from my understanding. It was more of like a mental health thing. But he was.
Do you believe that Mr. Wickens' mental health affects how he parents his children?
Mm-hmm. Yes.
Is that a yes?
Yes, I do.
You also asked the court to change legal custody, correct?
Mm-hmm.
You believe that you're not able to work with him on making decisions for the children's health, safety, and welfare?
No, I feel like there's been quite a few instances where I have tried to work with him since the last hearing that we had. And while there has been many times that we have been able to work together, there's been other times where I brought like a bigger thing to him as far as like vacations or things that have to do with like soccer or the kids or at school. And it's almost like the question isn't answered and instead it's deflected and it's just caused, another snowball of another conversation that I've lost track of. And that's kind of where I'm at. A lot of the conversations that come through to me, I kind of just will read or just browse over and I'll say, this doesn't really have anything to do with the kids, but he'll argue it does. But I don't feel like it does because a lot of it is just jabs at me.
Do you think that your husband's mental status is compromised?
My ex.
I'm sorry, Mr. Wiggins.
Yes, he has to take medication for his mental, whatever it is, and I do believe that it affects it in some way. His medication was changed when he was admitted, and I was told that since then he was doing better. But I've kind of just been seeing the same patterns.
How has these events affected negatively the children?
So they've seen obviously a lot of the conflict still. Whether it's on FaceTime when I'm calling or he's calling and something said, or
I'll need an example. You kind of go over it broadly. And
Can I get my
sure.
example? Okay.
Yes.
Sorry, I wasn't sure how much to bring up. Okay, so I have kind of separated just screenshots of things that were directly sent like to my daughter's phone or to her watch. Do you want me to read, or is it more of like a thing that I can just hand?
Can you pull out the highlights?
Yeah, so this one on the top, he texted my daughter. I can't remember which day this was. This had to do with soccer. I think it was right after December, but we had a conversation about soccer payments and how I wasn't able to pay for it that month. It kind of went on from there, but he texted my daughter directly and said, your mom can't pay for your soccer, so not sure when we can be continuing with JAG, sorry. And then it kind of just goes on from there. And then there was another instance where he sent kind of a long ordeal of things in between me and her on a group text, kind of just venting about things. And there was things related to drug use and...
How do you mean?
Can I read it?
Sure.
Okay, so it says like, at the bottom. So I'm about to do the biggest shot I can pack into my arm now. And it was
biggest shot he can pack into his arm? What did you take that to mean?
I took it as heroin.
Do you have any evidence that Mr. Wicken does heroin?
Not clear evidence, no. But I've had my own suspicions, I suppose, and
you think there may be drug use?
I have firmly believed that since the entire time that we've been apart, but I have been told otherwise. And instead it's been projected onto me that I do those things when I have, in reality, just been trying to parent and work 2 jobs.
How old are your kids?
The kids are 12 and 8.
12 and 8. Lillian, the 12-year-old? Okay.
Is 8.
Continue.
Yeah, so there's a part where he's texted Lily again, sorry, Lily, please don't read any of this. I'm sorry, I never got you a house. He sent, like, there's been a few times I highlighted in here that he has told me to take full custody and that he wanted to sign over his rights. There was this whole vent kind of that I actually intercepted before Lily saw it, but I took pictures of everything. Just this whole vent of.
Did Lily see the text where he said he wanted you? Excuse me.
Oh, sorry.
Did Lily see the text from Dad to you that said you should take full custody?
Oh, it's full custody? No, I don't believe so.
Was it meant for her? Or
no, those ones were meant for me. Yes.
Okay.
Yeah, there's just a really long part here where he's kind of like talking out loud, but just like going over just years and years of things between him and I, but it's to Lily. And it's such a long text, it had to be sent like as a file almost. There's, sorry, I'm just looking over some other stuff. He sent me some video stuff, audio recordings. And then there was a part where, as far as him telling me that his parents told him to kill himself. This was all sent to Lily's phone.
What was sent to Lily's phone?
Like he's saying, like I said, I'm going to block you on her phone. He's saying, I'm not lying to you, and they told me to kill myself. The psych ward was after I said, leave my kids alone. And then I said, okay, deleting this convo, goodbye.
So he sent a text to Lily that said his parents told him to kill himself?
Yeah, sent a lot of things like that to Lily's phone.
She just said that she was texting me and
how can you not just stop? Seriously, are you okay?
I am okay, yes, Your
I've
Honor.
been watching you fidget and you can't sit still even before we got started. You're walking around and are you okay?
I am very much okay.
Then sit and be still, please. You will have a chance to speak.
Okay. Sorry.
I got enough. Thank you.
Okay, I'm sorry. I thought I was a bit more organized and it's just a lot.
Well,
I do.
It's not easy presenting, is it?
No, it's not.
You're all set. Have a seat. Thank you very much.
Thank you.
You're okay. Mr. Wicken, then. Sir, would you raise your right hand with me?
Yes.
Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. What would you like to say?
I mean, do I respond to what she was just saying right there? Wow. So anytime I'm talking through Lily's phone, she is the one that initiates communication to me. She blocks me from communication. It's been addressed so many times. If you look at AppClose, there's months where I have to email to communicate. I bring this up that it's wrong, that we have children. I tried pushing us to go to therapy. I tried pushing, so last year when we talk about the 24th or whatever, in 25 for April, that was due to me surrendering child support in exchange for my children to finally be able to go to therapy. We're talking about me and like the mental health thing. So it was 2 weeks or 3 weeks that I was no longer there. And I'm asking her to not allow them to come over there while I figure out a living situation that gets them away from there because it's not a good environment for them. Beyond that, if we're talking, so like I've been on probation for pretrial and probation since 2024.
Wait, why are you on probation?
For OWI.
OWI?
I've had a tether on.
Where are you on probation?
I've been sentenced. I'm in the middle of it.
No, where? What court?
Oh, what court? So they transferred me, I think,
county?
It's 36.
Ingham County?
County, but it's a circuit court over there.
Ingham County?
Yeah, it's not 54 though.
That's okay. Ingham County, good enough.
Yep. So for 2 years, I've had a tether on, alcohol to monitor. I do random testing. So
that's good.
I do all, yeah, and I complete. So I go to 2 different therapists. I've gone to relapse.
Tell me why you go to therapy.
I go to therapy to improve myself. Like that wasn't court ordered or nothing like that. So for about 2 years, I've been going to therapy. It's a family counselor. It was mainly to help like people.
Have you been diagnosed with a mental health condition or disorder?
Just ADD. We're going back to like going to that hospital or whatever. Then when I go into that, like you can't stop the process when that happened after it was advocated that I needed to go or whatever. So like, it was unfortunate. There was a week period that I can't even communicate to anybody.
So you did have the hospital stay?
Yeah, correct.
And that was for ADD?
No, it was because someone advocated after telling me to kill myself that I was suicidal.
Your parents?
Yeah. After 2 days.
Parents told you to kill yourself and then you became suicidal.
No, I was not suicidal, and that's what so for 2 days, so as soon as that happened, I left the house. I'm going over to Wixom, where I've been working. I worked in Wixom, worked in Jackson.
What do?
I own a business in telecommunications, so I do telecommunication sales for fiber. I'm over in Wixom, staying in a hotel, working over there. I told her not to let them go back over there. I told her exactly what happened. I even said, in my view, it would be child abuse or like neglect if you put them over in there.
You're not living with your parents now?
I have gone back since because she needed me to be able to watch the kids because she could no longer do it. So I've been back there, but I'm moving out on May 10th.
You're moving out on May 10th?
Yes, correct.
Where are you moving to?
In Hazlitt, to be closer to where the children are.
You're moving closer to her?
To the children. They go to school in Hazlitt. So I think she's, I believe, moving into Okemos from Hazlitt. So not.
Did you know he's moving out of his parents?
I mentioned something about moving out eventually in the summer.
Okay, go ahead.
Yep. So, I mean, and again, the whole time, and we're talking about like the children being involved in like the communication parts of it. Like I've tried addressing that so hard. Like we're talking about making decisions and all that. She makes medical decisions. I've advocated to stop doing this without consulting me. That became such a big deal last year when my daughter had surgery all of a sudden. And I had already talked to the orthodontist people about that, and then they were like, they needed to confer with me. She had advocated all of a sudden the next day, and the surgery still went through, and they were like begging me to not, sue them or whatever for whatever it was, because I had a meeting with the director.
Let's back up a little bit. I got some questions. Why would you send your daughter a text saying that your parents told you to?
That was because she even said in there, she's talking to me in there because she will.
So you
not use app close.
You didn't send your daughter.
I'm not sending it to her. No, I'm talking to Jess. I'm talking directly to her when we're doing that because I cannot communicate to her through app close. I cannot communicate through her through anything.
She says you abuse app close. You talk about your.
I'm talking about our kids and what this impacts them.
So you're telling me that you never.
I would not say never. No.
Let me finish my question. You can only use app close as it relates to the children. That's it. Your personal stuff, your past stuff, that's not for app close.
Okay, so I might
need to stop that.
Okay, I've apologized for stuff in the past, but primarily what I'm talking about in there is directly involving our kids or what's impacting our kids, how we need to work better. And like for the last like day or so, we're sitting there communicating pretty well. It's good. And then I can't remember what we're talking about in there. And I don't know how we get to the point where go ahead.
Hey, look, you're kind of trailing off.
I know.
Look,
yeah.
the concern I'm getting from mom is that there might be a disorder that's affecting you from effectively parenting your children.
And I have 2 therapists and people that would say that's not the case at all. And they would imply that so out of all of us, she's the one that does not go to therapy. Out of all of us, she's not willing to do it.
Supposed to go to therapy?
To help her children? If the therapist is suggesting that it's better, yeah.
But you didn't file an answer to the motion, so I really don't know what therapist said what.
Well,
no idea.
I didn't know. I didn't get this. I mean, we were over in Virginia for daughter soccer, so I didn't have.
Okay, I just don't have an answer from you, whether you knew you had to file an answer or not. I don't know. Excuse me. I don't know what your position is because I'm just hearing from you now.
Okay. Yeah. I'm sorry. I did not know that I was supposed to respond to this.
Well, I'm not going to give you legal advice, but it does say,
Okay.
You would have got a document that said response to motion. You could have filled it out.
I got that packet. I think like.
That's fine. We're here. It's cool. Yeah. What else did you want to say?
I don't know I don't know how we move forward, I guess, with it. Like, I don't think so. My children, I don't think it's better for them to not have me. That it doesn't. makes little to no sense. And I'm trying to make changes for their environment and all that. And then again, like she said, we go back to I'm there every time the children are there now. Like I was working a lot, so now instead of like having my parents watch them for a couple hours, I make sure I'm.
Are you medicated for the ADD?
I am, correct.
Are you taking it now?
Yes. Yeah,
Is it working?
I'm actually going to be trying to change it today. So I have an appointment. It's taken a month to be addressed. So I'm trying to change it. I've taken Adderall for like 9 years. I don't think it's effective, or I don't like it anymore. You know, it's.
I gotcha. All right.
But instead of me just making a change or stopping it, like I feel like I had to go. Yeah.
So mom believes it's in the best interest of the children that she have full physical and full legal custody. What's your response to that?
I disagree. I object to it completely.
Disagree.
100%.
And where will the kids be? Do you know where you're moving next month?
Yeah, it's going to be in Hazlitt.
You already got a place?
In Boys Isle, yeah, correct.
You have a place, you got a lease, you got a mortgage?
It's a lease signed, yeah. And then
do you have that lease with you today?
I do. It's been sent to me as pictures. So it's not like an official one.
Has mom seen this place that you're going to take the kids to?
No, she hasn't. I haven't seen any of. That's okay. We'll leave that alone. No, she hasn't, but she's welcome to.
Now the kids going to be safe with you in this new place?
Yes, they've always been safe with me. If you can even, that's like my kids, there's no way they would, yeah, I don't understand where the unsafe part has ever come. That's all I ever try to do is.
Look, I'm just asking questions because I don't know you.
I understand. I've always advocated for the safety, and I try to do what's best for them. So I don't, that's why I'm here.
All right. Thank you, Mr. Wicken. I appreciate it. Anything else then, ma'am?
Well,
yeah, I got it.
Things, but yeah.
So today isn't, as I said when we started, the court isn't going to necessarily change custody today unless there was an emergency, and I don't see an emergency. I see some concerns, but I don't see any reason to enter any emergency orders. But I do think mom has demonstrated at least a threshold, at least a showing that maybe we ought to take a look at this custody order. That doesn't mean, Mr. Wiggin, that court's going to change custody. It just means that she's met the threshold to be able to engage in a full evidentiary hearing as to whether or not it's in the best interest of Lillian and Grayson that legal and physical custody be changed. That's all that means. Now, what happens next? I know not. I just know that you'll have an opportunity to present evidence relative to the best interest factors. I suggest that the two of you go talk to a lawyer because the next stage is a lot tougher than this stage is. You'll need to present evidence as it relates to all 12 best interest factors, and my referee will facilitate and will oversee the hearing. After he hears all the evidence, he'll make a recommendation to me as to whether or not his recommendation is whether or not it's in the best interest that custody be changed. In the meantime, though, I'm going to order that communication between the parties be limited to the best interests of the children and the best interests of the children alone. That's it. So no more talking about past stuff, Mr. Wicken. Water under the bridge. It's over. We can talk about soccer. We can talk about the dentist. We can talk about school, but nothing else. Do you understand?
Yes.
That may do a lot to move things along. Hopefully, the referee will sit the two of you down and see if something can be worked out so that the kids are safe and both parties are comfortable. Do you have any questions, ma'am? Mr. Wicken?
No, I do not. Thank you.
Okay. Thank you very much. Watch your email boxes. We'll get you an email and schedule a date when you got to come back. Please talk to a lawyer, and please respect the order regarding communication not involving the children. It just shouldn't happen.
Okay. Thank you.
Thank you. We'll get you an order before you leave. Thank you, everybody. Please, let's take a seat. The file that brings us together this morning is numbered 249047DM, and it's captioned Carpenter versus Carpenter. So it looks like we have Mr. Sean Carpenter here along with his attorney, Mr. John Hamola, and Christine, yes. Christine Carpenter is here as well. And as the court looks through the file, it appears that the court entered a judgment of divorce back on January 29th of the year 2025. And what's relevant to today's proceedings are the party's minor child, 10-year-old Madison. Mr. Carpenter, through his attorney, Mr. John Hamola, has asked this court to reconsider the earlier order in which the parties were awarded joint legal and joint physical custody. Now today, we aren't necessarily going to grind through all the best interest factors and have a protracted evidentiary hearing to determine whether or not custody should change. The focus of today's hearing is to decide whether or not there has been a material change in circumstances in the life of that child that would warrant an evaluation or an evidentiary hearing to determine whether or not it's in the best interest of Madison that custody should change. And from time to time, maybe the court would need to enter temporary orders to keep the parties moving along. But in any event, Ms. Carpenter has not filed an answer to the motion, so I'll just hear what she has to say on the record. Mr. Hamola, your argument for threshold.
Thank you, Your Honor.
You're welcome.
As set forth in Father's motion, judgment was entered January of last year. He reached out to me in regards to defendant mother and the parenting time arrangement, as well as some custody concerns. We're not so much concerned about the terminology as far as legal and physical custody. He believes they can work things out as far as important decisions involving Madison. But what's paramount in this is since the judgment, on average 3 or 4 overnights per month, quite a departure from what was agreed to in the judgment for a week on, week off pairing time. We believe that given the duration and the practice of the parties, that it obviously is significant enough to meet a threshold to revisit the parenting time. While parenting time can always be as agreed, it's been a continuous pattern where, aside from 3 or 4 overnights, Madison's in the care and custody of father in this matter, Your Honor. For those reasons, we'd ask that threshold be met as far as VARCA, and that this matter be scheduled for an evidentiary hearing. In the interim, we were concerned, obviously, you file a motion and then parties want to start all of a sudden filing the order. Madison has adjusted to this schedule. It's not that he's upset about, but then again, while there is telephone communications, things like that going on, ongoing relationship, as far as the home environment, it's with Dad, Your Honor.
Where does Madison go to school?
Owasso Public School.
Excuse me, Your Honor, I wasn't aware. All right, do the parties live near each other?
I believe Mom, last I knew, was in St. John's area.
Nope, I'm in Durand.
She's now in Durand?
All right. Thank you, Mr. Hamola.
Thank you, Your Honor.
Ms. Carpenter, would you join me at the podium? And would you raise your right hand with me, please? Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. You may put your hand down. And how would you respond then to the motion and Mr. Hamola's presentation this morning?
Well, I was running into a problem of getting her back and forth to school and having somebody watch her from Durand to Owasso.
Okay.
I did take her more than 2 to 3 days of the month. I took her on my days off, and I got it settled to where now I will take her every week or week on, week off. But I was having a trouble of getting somebody to watch her and to get her from Owasso schools and bring her to Durand.
Okay. And how long have you been having these troubles?
I've been having them for a while.
For a long time?
Yes.
And
I think it was before Christmas.
Before Christmas of last year? Or the 2025?
This year. It might have been a little longer.
We haven't had Christmas yet. It's only April, right? So Christmas 2025, correct?
Yes.
So months.
Yes.
And so what has your parenting time looked like since Christmas?
I basically I was taking her on my days off.
Okay, but what is that? I don't know your schedule. I have no idea. What does it look like?
Well, right now I've had 2 days off, but previous I've had more than 2 days off because I switched jobs.
Okay, but I still don't know what that looks like. What I'm trying to do, ma'am, is understand what the pattern has been for your parenting time since before Christmas. That's what I'm trying to understand.
I would take her at least 2-3 times a week.
Overnights 2 or 3
Yes.
times a week? Well, that's a little bit different than Mr. Hamola, who says 2 or 3 times a month.
I took her more than 2-3 times a month.
So if it was 2-3 times a week, that's pretty close to week on, week off. I suspect that if that's true, we wouldn't be here with a request to change custody.
Well, that's what I've been doing. I literally took her 2-3 times a week
Like what days?
Well, my schedule was where I would have 2 days off and then 3 days off.
Okay, so what days?
I was taking her, so it'd be like basically every other week I'd take her like Monday and Tuesday, and then he would have her Wednesday, Thursday, and then, or Friday, and I would take her Saturday, Sunday. But like I said, my schedule has switched now. And it just switched like 2-3 weeks ago.
2-3 weeks ago? To what?
Now I work every day besides 2 days a week, and that's Mondays and Wednesdays.
So what does that mean for Madison and her schedule?
Well, now I have a babysitter. Now I will take her week on, week off.
Now you have a babysitter?
Yes. I have somebody to transport her back and forth.
You have a babysitter that's also going to transport her?
Yes. I was having a trouble doing that. Her brother's actually going to pick her up from school and watch her, and then I will pick her up from there.
Where do you work?
I work in Howell.
You work in Howell? Do you think it's wise to uproot Madison from her schedule now and ship her from Durand to Owasso every day now because you have a babysitter that can do that?
Well, I was doing it before.
Well, but Mr. Hummel argues that you weren't, at least up until Christmas of last year.
Well, like I said, I was taking her like 3-4 times a week.
Well, you said it was 2 or 3 times. Is it 2 or 3 times or 3 or 4 times?
It'd be like 3 or 4 times.
Okay, where do you work? You said in Howell, but what do you do?
Assistant living.
Assistant living. I see. And what's your schedule now?
I work 3 to 11, and I have Mondays and Wednesdays off.
Mondays and Wednesdays off?
Yes.
So who would watch the Madison while you're working from 3 to 11, 6 days a week?
Her brother.
Her brother? How old's her brother?
He's 19.
Is that really fair to a 19-year-old to make him watch a 10-year-old?
He agreed to it.
And so he's responsible for the primary care for Madison while you're working this very, very busy schedule and to get her back and forth to Owasso schools every day?
Well, I'll do it on my days off.
But that's just Monday and Wednesdays.
And I would basically be taking her to school. The only thing he would do is pick her up from school.
But then you're working every other night, right?
Yes.
And you started this new schedule when?
Like, I think it's 2 weeks ago.
So you believe that right now you're taking her 3 or 4 overnights per week?
Yes.
But you said 2 or 3, but now it's 3 or 4.
Well, that was previous, before I switched jobs and I switched, my schedule got switched.
Since then. Okay. Anything else you wanted to say?
No.
Thank you. Mr. Hamola?
Just briefly.
Yes, sir.
I don't believe defendant mother's being truthful. This was verified by my client. This has gone on since the judgment entered in this matter. I actually recall him calling me about, hey, it's week on, week off. There were some problems early on, I remember. I just verified with my client. It's not 3-4 times a week. What it has been is since this motion was filed and Dad was looking to change it, because of the practice of the parties, it was 3 to 4 overnights per month. And my client has taken on the full responsibility here. But since the motion was filed, I believe Mom's, not scrambling, but she's realizing that, okay, Dad's going to make some changes here. It's certainly worthy of a vodvark. I don't think she's being honest.
Yeah, no question, Mr. Romola. Yeah, first and foremost, I do think that there's a material change here that would move this matter on to a full evidentiary hearing, and the central question will be whether or not it's in the best interest of Madison that physical custody change. I think that there's some challenges on Mom's side, and hey, everybody has challenges and nobody's upset with you. And this isn't a focus on the parties. It's a focus on the minor child. And based on the offer of proof by Mr. Homola, it looks like Madison has had a pretty steady schedule with Dad since at least before Christmas. And Mom, Ms. Carpenter, I'm just not sure where you're coming from. You know, a lot of what you're telling me, I'm just not sure about. First, you told me 2 or 3 nights a week, then it's 3 or 4, and now you've got a 19-year-old son, which, bless his heart, that's a lot to put on a 19-year-old to make him a primary daycare provider and transport for at least 3 days out of the week. So I'm going to change the schedule a little bit. And the court is not changing custody. It's just going to enter a temporary order changing parenting time until this can get before a referee and can get this figured out with some finality. Mom, your parenting time every week will be on your 2 days off. You'll have Monday and Wednesday every night. Mr. Mola, can you work out with Ms. Carpenter times, or do I need to put that on the record for you?
Oh, we can work that out.
Do you think you can talk to Mr. Homola and work out times that's convenient for you? You seem like nice folks, but I don't know you and I don't know your lives and I don't know what works. But I'd like Mom to have the time that she's off to be with her daughter. Monday overnight, Wednesday overnight every week. If those are her days off, if she has days off on the weekends, she should have those too. So I'll ask you to sit tight, talk to Jillian, work out the times, and we'll put it in order for you. In the meantime, holiday schedule will stay the same. In the meantime, we'll get you a date to get you back in front of the referee where he will evaluate the best interest factors. You wanted to say something?
I do want to say something. Well,
could you address the court from the podium, please?
I understand that he's had her quite often, but I'm the one that always takes her to the doctor's appointment, makes the doctor's appointment, and I'm the one that took her back and forth when we were taking her.
Thank you.
When we were splitting it.
Yes. Thank you. Stick around. Jillian will come see you and try to point down some hours that's convenient for you to exchange. Thank you so much.
What time works best for you? After school.
Courthouse case, People State of Michigan versus Courthouse Junior.
Alexander on behalf of the people broker.
Morning, Rob J. Cohen, Wardell Smith, Wardell Station.
Mr. Senator, this is your motion.
Thank you. Here at this time, the people are going to be requesting that defendant's bond be set as denied in this case. As the court is aware, this case was originally charged as a GBH strangulation and a domestic violence charge that was remanded to this court at preliminary exam. Since the time of preliminary exam, it's come to the people's attention that Mr. Smith has been consistently and pretty egregiously violating his bond. While he was in custody prior to the preliminary exam pending this case, he had violated his bond with his jail calls, leading to his phone and text privileges to be revoked. Leading up to exam, he then bonded out of the jail. And in that time, prior to and since after the exam, he was using, not only calling the victim himself, but also using law enforcement 911 services to harass and track the victim. The court, I believe I sent over a few of the reports that we received with the CAD notes related to what those calls entailed. Yeah. Some of those saying there were calls that the wife referring to the victim in this case, and children are in danger, someone's trying to harm them, that they want the wife's cell phone tracked. There were other calls that were made indicating that there had been a shooting in which law enforcement responded and the scene was deemed there was no shooting and that the house was secure. Those are just some of the things that not only harass the victim, but also put the victim's safety in danger for law enforcement responding to incidents reported as shootings that's also taking up community resources. Come to find out, after the people filed this emergency bond motion that night, the defendant was picked up by Ypsilanti Police Department, in which he is accused of stabbing.
Judge, I'm sorry, with all due respect to Madam Prosecutor, I'm going to object to this. I'm not the attorney on what may be another case, but if extraneous, she was kind enough to let me see the police report. But again, though, I don't think that should have a bearing on this bond hearing regarding harassing phone calls.
And Your Honor, I think this just adds to the bond violations that he has committed.
I'll hear. If it's irrelevant to my consideration, then certainly.
That same night, the people filed the bond motion. Defendant was picked up by YPD in to this A1 case that did lead to future charges, 3 charges of assault with intent to murder against the 3 victims in this case. In that case, it is alleged that defendant, in further violation of his bond at the time, was high and had possession of crack on him. He admitted to that to officers. And in that time span, he had stabbed 3 family members that he was residing with in the face and neck areas with a folding knife and or a, I guess, serving fork, a pitchfork of some kind for food. And that led to all 3 victims being transported to the hospital. They're now okay, but that did lead to more charges. The people also, in speaking with Pittsfield Police Department, in speaking with the victim, she has indicated that at this time, due to her fear of defendant and of what has been going on, she is looking to also reauthorize that dismissed great bodily harm strangulation charge that was dismissed in exam, and that is the people's intention as well at this time. So with all that, he said would ask for his bond to be set as denied due to these flagrant and pretty egregious bond violations that have been committed by this defendant.
Judge Schiller, the victim, as far as the phone call, has been in a relationship with Mr. Wardell for 18 years. They have 6 kids, 4 of which are between Wardell and the victim. I mean, any phone call that was ever made to check up on the kids, and not necessarily at any harassment stage. Just wanted to know that his kids were safe. And other than that, I think the court should take that into consideration. Again,
those are the phone calls that he made from the jail you're talking about.
The jail, and allegedly once he was out on bond, the prosecutors alleged that once he was out on bond, he called the FBI, he called the Pittsfield Township Police. But I would argue that any any call that was ever made was just for the sake of the children, to make sure they're safe, not in harassment for Latronda. Is that what it is? Latronda. Again, his significant.
Why would you call saying there was a shooting when there wasn't one? How does that protect the victim and the children?
Yeah, my client. Again, Judge, I haven't heard all the phone calls, but again, I would just argue in general, the calls were made just for the sake of the children and nothing more. And as far as the stabbing and
well, but was there? I guess if that's the case, if that's what you're telling the court, I understand that, Mr. Killawall. Is there any basis for those calls?
Any basis other than
father? Fine, I'm the father of children, but I can't just call the FBI and say X to them. I mean, is there a reason other than to harass the victim,
Judge,
that these calls were made?
Other than attorney-client privilege, any call that was made to the FBI was made that saying, I know my kids are safe, don't worry about it. I mean, there may have been a second call to the FBI that says, hey, I know my children are safe. Again, everything was premised on the safety of his children. And as far as the other charges, again, I don't know if I'm ever going to be appointed on the case of the allegations that he stabbed people. I did talk to him briefly about that, but I'm not his attorney. So far he has the PD. They are checking to see if they have conflicts. If Tracy had told me they have a conflict, but they're working on that, so I don't know. But all that being said, Judge, is again, I would ask the court just to consider the phone call issue itself and not the other issue of the stabbings.
And Your Honor, I will also advise the court that the phone calls and to the victim as well as to law enforcement are being submitted as another report potentially for aggravated stalking charges that will be reviewed potentially this week.
Anything else, Mr. Cole?
No, Your Honor.
Based upon all of that, and quite frankly, at this point, I don't have to take into account the allegations regarding the stabbings, and they'll let those bonds happen when those charges come forward. But given the fact that there were calls to law enforcement, and I specifically asked the question so that I could be sure that there wasn't a basis upon which he was making these calls, clearly making these calls in this court's mind upon review of the report to harass the victim in this case. And that would clearly be a violation of his bond. As to the, and let me just also be clear, also as to the stabbings, well, not taking that into account, his possession and or use of a controlled substance, I think this court can take into account. And in reviewing everything, I think the defendant not only has violated his bond, but constitutes a significant danger public to the community at large, as well as specifically to the victims and the victim in this case. And so I will grant the emergency motion for bond modification. Defendant's bond is hereby ordered revoked. It will stand at denied at this time.
Thank you.
Thank you.
Thank you.
I didn't see you there.
John West, Joshua Gross. It's like 3 minutes, correct?
We're not playing on to it. Seems small.
All right, it looks like he's going to be pleading guilty to 2. 1 will be dismissed. Is that the plan?
That is, Judge.
The one to be dismissed will be
194.
194. Okay, he pleads to 192, 193. Joshua, is that you? Please go in front of that lady first. She's going to swear you in and.
Raise your right hand, you swear or affirm to repeat the whole truth and accept the copy of it. Yes.
He's taking it pretty well.
Right thumb, right thumb.
I think he's confident.
Okay.
That conversation was
We're all right.
We're gonna put, yeah, but we're gonna put him on the mental health case.
Yeah, he understands what she's charged with. He told me what happened. He understands what's going on. So he did the department's really good. He doesn't
look like straight up.
Which is why he was in the hospital, which is what started all this.
Okay, you know, stand in front of judge, okay?
Are you Joshua Gross?
Yes.
Am I pronouncing that correctly, Sir Gross?
Yes.
You were here with Mr. West, your attorney?
Sorry, I love Mr. West. Haven't talked to him in 3 months since I've been here.
Okay.
But it's fine. You know. I finally have, though. I have within these 3 months. I have talked to him.
Okay.
So glad to talk to him. You know, to see what my choices are.
Okay. Do you understand you're going to be entering some pleas of guilty?
Yes.
2 pleas of guilty in some cases that have been charged. A 3rd case that you are indicted for will be dismissed. Is that your understanding of the plan today?
Yes.
Yes.
Yes, sir.
Okay. Does the defendant, who's here with Mr. West, his attorney, and the state's attorney, does the defendant waive a formal reading of the indictments and the arraignments here? Can we proceed in summary?
Yes, Your Honor, we can.
First of all, in 26 CR 192, Joshua, this indictment states that on or about January 18th, 2026, just a few months ago, in Jefferson County, Texas, you committed the 3rd-degree felony of harassment of a public servant, which states that with the intent to assault, harass, or alarm this person, you know to be a public servant, namely a Baptist hospital nurse. You apparently, let's spit at the lady.
Spit on him, sir.
Spit on him. Jalen?
Yes, sir.
How do you spell that?
That's correct spelling, Judge. I confirmed it.
Jaylin.
No, it's.
The spelling in the indictment
It's-
is correct.
The
Jeff.
spelling is correct.
Yes, sir.
It's phonetically.
I've talked to that individual. They've approved
It's
this
misspelled
agreement.
in the probable cause affidavit. They had the L before the Y. Jalyet is the way it phonetically looks, but it's Jalen.
Yes, sir.
Okay. The nurse, who are there to help you, and you can't be harassing them. This is a third-degree felony, which carries with it no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. It's serious. You understand? 26 CR 193 is another case that you've been charged with on or about January 18th, 2026 in Jefferson County, Texas. This alleges assault on a public servant where you intentionally, knowingly, or recklessly caused bodily injury to a Jefferson County Corrections officer by striking that person in the face with your hands. Do you understand what you're charged with there?
Yes.
This is also a third-degree felony, which carries with it no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're charged with in these two cases?
Yes, sir.
There's a third case that you've been charged with, 26 CR 194, assault on a public servant, which is to be dismissed as part of this agreement to plead guilty on 2 cases. Is that your understanding?
Sure.
In each of these 2 cases that are 192 and 193 that you're indicted for, that you were going to be pleading guilty to, these are third-degree felonies. Each of them, if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
In each case.
Yes, sir.
Agreements have been reached where you would be pleading guilty and placed on deferred or unadjudicated probation in each case for 10 years. A third case will be dismissed, 194. Is that your understanding of the plan?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Can I do it right now and have it done?
What do you say?
Can I go back on my deal and just have me sentenced to take the sign off for the time to go to prison?
Do you want to go to prison instead of probation?
Yes, because I cannot do probation. I have no home, I have no help, I have no income, no source of help or outreach. I just have to be going to prison. I'd like to sign off right now to go to prison. Under my own compensation.
Have you ever been convicted of a felony before? Have you ever been convicted of a crime before?
Yes, I have.
Of a felony?
No, sir.
All right. You don't want a felony conviction if you can avoid it.
I'd like to.
It closes all kinds of doors of opportunities and you're not able, you lose rights, constitutional rights, like you're unable to vote, hold public office. There are all kinds of things that placing you on probation, a deferred or unadjudicated probation, means that as long as you do well, your record stays clear. It's not a conviction of any of this.
Sir.
Most of these terms and conditions of probation are the same terms and conditions of probation I have to follow.
Yes, sir.
Like don't commit a crime is the first one. I got to follow that.
Yes, sir.
Yeah. Pay your bills. Be responsible. Don't harm others.
Completely understand, Your Honor. Pardon my interruption, Your Honor. I understand before I stand to what I'm saying, and I would like to revoke my right to
Okay.
to do what I'm talking about. I would like to go into detail to go ahead and sign for my prison time.
Well, you're looking at up to standby. And these are all 30 felonies. You're looking at up to 30 years in prison on all of this.
Yes, sir. I understand. I have no.
Well, I can tell you, I've done this
I've been in criminal law for a long time.
No one's ever wanted to do this or broken.
Yeah, I think people from time to time say it, but after they speak to their lawyer a little more, they understand that it's not a wise choice. That's what I'm going to do is if that's what you want to do, let's take a couple of days here and let him talk to you. You ask him all the questions about what else.
He did on the law book for an interruption. I wish to fire my lawyer right now.
And do what?
And stand on my own counsel and ask to sign to go to just be tried.
Have you ever done such a thing before?
Yes, sir. In juvenile court.
Oh, well, this isn't juvenile court. This is the big leagues. You're looking at 30 years in prison.
I don't want my lawyer anymore. I'd like to sign for him.
And who's going to represent you?
My son.
You think you're competent to represent yourself?
Yes, sir.
Why do you say that? How far did you go in school?
High school.
How far did you go in high school?
All the way through high school.
You graduated from high school?
Yes, sir.
Where?
Finished my 11th and 12th grade in all different places. So.
Yeah. All right. There's an old saying that's a very famous saying that is a wise one. A person who represents themselves has a fool for a client. And there's some good reasons. Some people, a few who are lawyers, who have legal experience may do well. But you're looking at 30 years in prison. And here, these are 10 years together. You do well. It ends in 3 1/3 years, a third. I can shorten it to 1/3 if you do well. 3 1/3 years.
Part of my interruption, Your Honor, there's no way that I'm going to be able to escape and maintain and even make my probation office appointment. To be able to
Why?
The fact I have no transportation, I have no.
Well, we accommodate people who have problems like that. Some people are homeless, and we work with you.
Not wish to be in the ward.
Sir?
I do not wish to be in the ward.
I'm sorry.
I do not wish to be in the
Doesn't want to be in the free world. He wants to go to the prison, Judge.
All right. Well, that's one way to think, and you're entitled to your own ideas, but you can understand only a few people think that out of 7 billion people on the planet.
One of those 1% that
It's not a 1%. It's less than that. But if you want to represent yourself, that's fine. You've got to do that intelligently with reflection. And Mr. West is going to continue to help you if necessary. You don't have to get advice from him, but he's going to be with you, because everyone who represents themselves in 20 years has failed miserably. They don't do well. And they end up being, if they follow through with it, most people change their minds realizing after they reflect that this is an unwise choice. And you're entitled to make bad choices, but you ought to make good choices. And this plan is fashioned to keep your record clean. You don't have a felony conviction yet, do you? No.
No, yes.
Not yet.
Arrest, but no felony conviction.
All right. You don't want felony. It just, you lose innumerable opportunities, and all probation, and our probation office has a 93% success rate with probationers. 93%. We brag about that, and they move on with their life, and on deferred, they don't get found guilty. They move on, and they are the best they can be. If you think you're destined to fail, that's a really negative way to think, but you ought to be optimistic. I think that's the natural thing. Well, where's your family located? Do you know?
Mostly all dead.
They're all dead? Well, you've got siblings, don't you?
My brother's dead to me.
He's dead to you. Oh, okay. But he's still alive. You just don't have any contact with him. All right.
I just don't.
Okay. Well, what's going to happen is now this is going to,
My father.
but it sounds like you've got some bad fortune, but we all do from time to time with bad times, good times.
Dad wasn't around. Part of my interruption on. Dad wasn't around. He was in prison in Dallas, Texas.
Where is he now? You don't know?
Never knew him. I know his name. His nickname Wild Bill. Never got to spend no time with him.
It sounds like a bad role model for you, but
Like
you know,
Wild Bill, like Billy the Kid.
you're smart enough to know. Well, you've seen people make mistakes like your dad, right? You don't want to make the same mistakes.
I don't really know what he's done in life. I know he's
I know, but
neighborhoods where
don't you?
shootouts, drugs,
What we fashioned, Joshua, is what's been fashioned between the lawyers is an opportunity for you to walk out of here in 24 hours as a free man and make a life, make a family, and be a good role model.
I have a son. I have 2 sons.
You have 2 sons? Well,
I have many wives.
Well, good. Well, aren't the sons needing a father? Not in prison.
They're taken care of. They know who I am.
Where's the role modeling?
They going on 9.
That's what a parent does. I've been a parent for 40 years.
Their moms are there and their uncles and their
They need a
grandfathers are there
dad.
and their grandmothers.
They need a dad.
No, that's
Well, not one that elected to go to prison rather than a chance to be a free person to handle responsibilities as a father and a loving family member and to set good examples. This is your chance to do that, right?
Pardon me, Your Honor. Pardon my interruption, Your Honor.
Sir?
Pardon my interruption, Your Honor. My 8-year-old son going on 9 and my 17-year-old son going on 18. They both know I'm in here, and
He's 25, Judge.
Who is?
This man.
they both know that I'm in here.
Wait, how old is your oldest child?
17 going on 18 years old.
How could that be? You're 25 years of age. Did you have him when you were 8?
Younger than that, Your Honor.
Huh?
Younger than that, Your Honor, and then that would be trying to prove about physics and chemistry and biology. If you want to get that into anatomy.
May I suggest an evaluation, Judge?
I think I've heard enough here.
Yes, sir.
It's fine. Your Honor. Good day, Your Honor.
All right, John.
For me to be fair.
We need a competency evaluation.
Me and Mr. Hand have already talked about that one.
Okay. Your answer. This is all collapsing on you because you're 25 and you're claiming your children are 17 and 18, which is naturally
17
possible.
going on 18. Pardon me, Your Honor. Pardon my interruption. Have a good day. Good day.
And your statement, your answers are really incoherent. What we're going to do is get a doctor to come in and talk to you and evaluate you. That's what we're going to do. That's the orders of the court.
November.
Dr. Edward Kahn will be ordered to review the defendant for competency. I think that's the right thing to do, especially we're going to. Okay, time out. Okay, we're going to try to help you here. Okay, Joshua, good luck. All right, the court will order Dr. Kahn to evaluate for competency.
Follow a motion or just go ahead and
follow it up, please. But I mean,
it's ordered. It's a matter. I actually need to put the paperwork to.
It's obvious.
I'll have those.
I'll prep the order and get that order sent over to you.
Yeah. Okay. So, what do we have?
Brandon Lee Allen. He's we think there's some mental issues with him. So,
Brandon, is he a person I have not seen before here today?
He's pro se, he says, and he's asked to us, like I say, he sent an email asking us to kill him. He's tried to commit suicide the other day in jail. I just want the court to, on its own motion, since you got the evidence in there from the jail.
Well, should I talk to him?
You can if you want to, but
let's see.
I think we should.
Let's bring Brandon Allen out and give him an opportunity. Although Doesn't he have a lawyer?
No, sir. It says in pro se.
Well, it says Don Dusler is his attorney.
No, that's Brandon Dorsey's, Brandon Allen.
No, look, this is Brandon Allen. It says attorney of record Don Dusler.
I know, but he's since gone pro se, Judge.
All right, come on up, sir. All right, you're Brandon Lee Allen, right, Mr. Allen? Yeah, okay. And is it 2 cases? 25 CR 871 and 25 CR 872. You're charged with the 3rd-degree felonies of assault on a security officer and assault on hospital personnel. Also, that goes on to allege that you have a burglary of a habitation conviction in 2020 in the court next door, the 252nd. So paragraphs 1 and 2 in each of these cases are 3rd-degree felonies enhanced to 2nd-degree felony if all of this was true. So you're looking at no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000 in each of these cases. Do you understand?
No, sir, I do not.
All right. Do you have it says Don Dusler is your lawyer?
No, sir, he is not.
Okay. Well, that's why you don't understand, because you don't have anybody that's helping you.
I know litigation, sir.
Well, you said you didn't understand.
I don't understand how you can charge me with that, sir.
I didn't charge you the grand jury charge.
I understand.
Well, do you understand or not?
I don't.
You said you did, and now you don't.
I don't understand.
Are you schizophrenic? Have you ever been?
Yeah, I suffer from depression, dude.
Yeah,
that's why they boosted my court date. Yeah. I was at a mental hospital.
Okay.
That's why I was there.
All right.
That's why I busted out the room and ran down the street.
Okay.
And started getting restrained. And now you're trying to send me in prison today.
Were you running at like a half gown or something?
Yes, I was fully checked in. The cop brought me there that day.
So it says Don Dusler was your lawyer.
Bro.
Why do you keep interrupting? Is that what you do?
Hey, listen, sir.
No. Look, sir.
This is not a game.
All right, go on in. Go outside until you can be. You're rude, and you don't follow the rules, sir. You're in timeout, like a child. Timeout. All right, actually, he's got some written things here.
Yes, sir.
That have been written that the court finds are very disturbing, to say the least.
Trying to get him examined, Judge. Just had him look at. He's also had several incidents out the jail, use of force. That's why he gets agitated. He either hurts himself or tries to hurt others. So
I refuse any penalties. I want the death penalty by legal injection.
yes, sir.
Okay,
So
that's what he's writing. All right. We're going to get Dr. Ed Rapon to review him and see if he is competent or not.
thank you. Yes, he is on.
Do you know?
Watch, so y'all.
Do you know an interesting fact about mental incompetency and insanity? You have to be competent to ever become insane.
Are we doing?
All right, we're in recess.
You got to be competent to be insane. But you might have to be a little crazy. Hang out with me. Oh, ladies and gentlemen, it's been one of those nights. It's been one of those days. Unhinged people all the way around. From Judge Middleton's guy who thought he was going to bring him a whatever of IPA and get the case dismissed. How could you imagine that was ever going to work with Judge Middleton? I don't know. To all the people and their crazy behavior in front of their poor children, in front of Judge Stewart, and my horrible labeling capabilities, that was kind of unhinged too. Thank you very much, ladies and gentlemen, for hanging out with me. Hold on one second. Random cough. Ladies and gentlemen, I'm going to do something interesting. I'm going to redirect to a new little project I have going on. It's the channel that is not monetized, doesn't have hardly any followers at all. It is the Wolfbot channel, where it's just streaming some raw, unedited court hearings from 2 years ago from around this date and time. Right now, Judge Boyd is on, and it is live and it's running, and we're about to go over there as soon as we end here. But first, ladies and gentlemen, I do want to say thank you to everybody who hung out tonight. I have this little thing. Look at this. Suwadi Wiz. Thank you so very much for that 100 Thai bot. Always awesome to see. Thank you so much, everybody, for coming out and hanging out. I can't say all the names. They're on the screen right now. You see them. All these people, they're cool. Especially Mama Wolf. Mama Wolf and Rhonda. Make sure you are weather aware, because weather is crazy out there, especially right now. Ladies and gentlemen, for the time being, I'm your lone wolf Usul. Thank you so much for hanging out with me. I'll see y'all next time. Go over and hang out with Wolfbot. I'll probably be over there in chat. Maybe subscribe to that channel for me. Help out the channel a whole lot. I'm gonna give everybody some heads up here. We're probably gonna have some almost 2-year-old OG full dockets of Judge Fleischer. As soon as I know they're here. I don't really have to look hard. But as soon as I get them put together, get it all packaged up, get it over there to the streaming, the Wolfbot streaming computer, that's gonna be happening. But Wolfbot has a couple more hours to go before it's done for the day. So go give it a shout out. Hang out with it. I want to say thank you for hanging out with me. I'm your lone wolf Usul, your humble host, your wily curator. And I'll see you next time. Y'all have a great night. Ferris Bueller's still cool. That's all.